First of all, I really would like to thank Labuan IBFC for inviting me to share this morning with you, chatting about a subject that has kind of grown close to heart. Just to add on a little bit of the introduction, I actually practiced law in Malaysia for about 27 years. And I am now in Vancouver office of BLG. I also study theology in Regent College in Vancouver. And BLG, perhaps I could give a short introduction of BLG. It's a national law firm in Vancouver. We have about 750 lawyers. The offices are across Vancouver. But I particularly work with the team in the Vancouver office that assists high net worth families in actually offshore of Vancouver. Basically, I work with high net worth families who may not have any nexus with Vancouver. They may not have beneficiaries, they may not have assets in Vancouver, but basically assisting them to do a structure to transfer wealth intergenerationally, across generations, we call that. A stewardship way of preserving and protecting their wealth. The reason that really attracted me to work with the team in the Vancouver office is because they have developed quite a holistic approach towards wealth transfer. In the holistic global terminology, we define wealth to mean more than the material assets. We consider wealth of the family to consist also of the family unity, family traditions, family values, which basically actually are more important to the family when we sit down with them. It's just that a lot of time they do not think of flushing these values on the board table to talk about it, but it forms the core of who they are. And increasingly, I think reports will show that you may have a very good structure in protecting and preserving and transferring wealth in your material wealth. But if you don't have a structure to also organize the family together, to protect the family identity so that children are rooted to know who they are, then very soon, when the founders or even when the founders' second generation have gone by, the third and fourth generation have no gluing factor to know who they are, and the asset protection structure becomes a mere money source, which of course at most time when it first started, it was never intended to be that way for the founder. So the question is, how do we also walk alongside family, not only to see how we could help them to protect and have their wealth in a structure that can bless generations to come, but also at the same time assisting them to have a structure that captures what we call the soft issue. Actually, these soft issues of family tradition and all this, they are the harder issues to capture. But nonetheless, doing the best as service providers to walk alongside them to help them form something like that. So when I look at what BLG does, it really resonates greatly with our Asian culture because down-rooted, we are all value-based, family-based. So, and I started working with them. So we have teams that focus on different jurisdictions. I look a lot in terms of Asia, Asia meaning Malaysia, Singapore, Indonesia, Philippines, Hong Kong, and now we are starting a representative office in Beijing, China. So thank you very much for this opportunity. Just share the experience that we have in working alongside families in this area. So perhaps just quickly to say that the objective of this presentation chiefly is to share with you all the holistic approach to global estate planning. But when Labuan IBFC also informed me that, among the audience, there may be people like financial advisors or, tax consultants who might not be directly involved in the structure that comes out. They might not see their visible role in it. So I thought maybe I could also, talk about the second limb, about an advisor role and early involvement in assisting high net worth families in their global estate planning. I mean, the very fact that you are here this morning obviously indicate that you have some interest in this area. But the question is, would you want to stay invested in a process of knowing more about it? Would you want to talk more about it with your clients, even though you might not see a visible role in the structure that may come? I believe there is good value in doing that. First of all, the advisor role, I would say, we all know that if we want to maintain a substantial and meaningful relationship with existing client, we as advisor, in all areas of practice, really, need to be continuously involved in adopting measures to strengthen our role by staying relevant to clients' needs. We would like to anticipate clients' demands and respond with appropriate services. It might not be that you could immediately come up with the answer, but you have formed a network of community that could walk alongside to talk about it. So, and of course, we want to remain competitive in our way. If you don't know it, you won't talk about it, and soon you are outside of that area of influence in that sense. So, we would say global estate planning is fast becoming a necessity for high net worth families, and we should be positioned to talk about it. I mean, we have already heard Labuan IBFC, Aslin, right, who introduced to speak about the fact of the source of fund that is available now. We have what we call the baby boomers generation coming of age in Malaysia. Baby boomers defined as those born between 1946 and 1964. I count for one. Some of you in the audience count for one. And a lot of families have their founder, their head, in the baby boomer generation. They're coming at a stage whereby they are considering what to do with the transfer of their wealth. They may not be even considering, because this is not a very happy issue. Because when you talk about these things, almost mortality is facing you, which not necessarily will be. We always remind the client, you have spent so much effort into creating wealth. It is such a joy to really sit to think how your wealth can be a blessing to the generation come in a very organized way. We do corporate governance all the time as corporations, their structure grow. Similarly with a family that has amassed great wealth, it is a joy to look at it. It's all where your starting point is. But the fact remains is in Malaysia, we have so many families of high net worth that needs to look at that. And if you don't talk about it, some other advisors will approach the clients to talk about it. So we say that by adopting a proactive approach in assisting the family to consider global estate planning, you as the advisor will strengthen your tie by providing value-added service to family in anticipation of their need. As an advisor, you will be privy to the planning process likely, and hopefully be part of the solution. And along the way, I will show that in a holistic approach to global estate planning, because of the various entity and structures that may be set up, a lot of time trusted advisors may be invited to be part of the members of various entities. As I go along, I would highlight that. So therefore, some people will say, I'm not a trustee. Why would I want to know more about this? It is really understanding that our clients' needs and dynamics evolve. And in order to stay close to the family and care for their concerns, it would be good just to get ourselves invested in the process of knowing and be able to value add by offering certain solutions, even by talking generally. And I also feel deeply in my heart that because this area of global estate planning is really something very new to our families. And we need to beef up our own industry in Malaysia. And the more we talk about it among ourselves, the more connected we are with the problems of various nature, various sizes, and the more we are able to impact the authority, like Labuan IBFC. They are always open to consider, because when we adopt certain structures from overseas, they are just shell structure. They don't have the value of our family in it. They don't have the needs and the objective of family in it. Of course, roughly, there are some universal objectives, but there are a lot of objectives that are peculiar to Malaysian families. They're close to their heart, different challenges. And that's when we need to beef up the neutral structure into something that's relevant to our family at their roots. So the more we talk about it, the more we understand different needs, and the more we are able to come up with something meaningful, not just cookie cutter. This is what everybody does. ticket. No, our clients are talking about doing an exercise that can affect their generations to come when they are no longer there. You know, unlike starting a business, they expect to be there to run it. But in terms of global estate planning, it will come a stage. My pastor always say, in Canada, the mortality rate is 100%. Now, the mortality rate is 100% everywhere. So eventually, wherever the founders start, there will be a point the person who structure it is no longer there. You need to capture their essence, their voice, to continue that. So therefore, I feel very strongly that a lot of times I am also asked to speak with financial institutions who may not have trust services. But nonetheless, they invite me to speak to their high net worth family because they consider that, first of all, they are value adding to the family. They are showing that they care. Because even though if the family set up trust and all that, they won't have a division to serve them. But at least they are bringing valuable information to the client. But at the same time, they are also likely to be privy to their planning. They will tell clients, you know, if you do set up a mid-shore structure or an offshore structure, don't move your assets, okay? Because it's only ownership that changed, but it still needs to be invested. I'm like, right? Don't move it. Stay with me. Remember, it was me who talked to you about it. So it's a very, you know, I think there's, I can't remember who said it. People don't care how much we know until they know how much we care. Basically, it's that bottom line, right? So therefore, it will be good, you know, that even you might not be directly impacted in terms of your business, but you stay privy to the need and be able to talk about with your client is a good role. So, am I right? Yeah, okay. Am I talking too fast? I'm okay, right? Yeah, so sometimes people will say that I'm like a bullet train. So I'm going to talk about, now go into holistic global estate planning. So when we talk about high net worth family, what are the characteristics? So because when we know who they are, we are able then to approach certain conversations starting right. So of course we expect high net worth family to have significant capital base. So I would say we know in the last 30 years, families here, the capital base has really expanded. But actually, I wouldn't say that the assets value of families only accumulated in this generation. I would say that it has only become visibly significant in this generation. Prior to globalization, you know, our stock exchange listing, prior to all that, families still have a lot of wealth. Think of families in Penang, think of family in Kuala, have rooted with very large estate that sprung on even in the early 1900s. But because there is, you know, or rather the other way around, with listing exercises, with globalization, with joint venture, the wealth is, the value is now flashed out. Now they kind of realize they have a lot because nobody values their Sundaram Berhad shares every day. But if you're going to do a joint venture, you would have to value it and look at how much it is before the other party would give you a value to what you want to sell them. So, and the same thing like listing. When it comes to listing, you get to know your value. So I always like to quote this client. He says, you know, Millie, if I give my children 3-4 million, I already think it's so much because I started with hardly any. But if I give them 30-40 million, I think it's criminal. So we kind of know what he means. He now realizes it's a lot. I can't just think of giving directly because for most of our generations in Malaysia until now, even when I started practice, right, in the 1980s, this is not an issue that's on the table. People are still talking about even doing a will, getting a client to do a will is such a adventurous thing, you know. There are different motivations. A lot of people say, you know, I've got to pass everything to the children. If I die without a will, since I'm going to give them equal share, the Administration Act would deal with it, you know, so why do I want a will? But now it's different because of the value of it. When they see the value, they know something is not right if I give everything directly to their assessment. So significant capital base is one of the characteristics. The other one, of course, annual net increase, basically meaning the capital will grow. The family will not be using the whole amount every year. You expect the significant capital base to increase and be more significant. And of course, we have a situation where it's capital in diverse geographical locations. So that is a challenge on its own. We speak a lot about, bankers speak a lot about asset diversification. You put your asset in different categories. But now families also talk about jurisdiction diversification. Not putting all your eggs in one basket and expanding in different areas. And of course, opportunities call and you go to different areas. So a lot of our high net worth families in Malaysia, for sure, will have capital in diverse geographical locations. And then we have growth in family membership. This is almost a given in every family that we act for, perhaps except for families in mainland China, families from China. In most other jurisdictions, we talk about pyramid. You have father and mother, you have three children, you have 9 grandchildren, so the family becomes like a pyramid growing, the base growing long. In China, we talk about the family, an inverted pyramid. Father, mother, just one child, single child policy, then a single child marries, single child, they have one child. So that inverted pyramid will present a different set of challenges when we do holistic global estate planning for that. But for our Malaysian family and for most Asian families, we talk about growth in family memberships across generations as almost a given. Family may be growing slower in sizes, but they are still growing, And then we have the last characteristic is geographical dispersion of family members. I would say this is one of the key motivator for families that we act for in Asia. We know that Asian families are very prone to sending our children overseas to study. And a lot of times you can't tell them don't fall in love, don't settle down. So, previously, when I started practice, when I had my client, they would say things like, I tell them if they don't come back, I'm going to turn off the tap. And a lot of us come back. But now the baby boomers generation parents are much more indulgent. They brought up the children in such a way to be much more adventurous. So they go, and if they settle down in different jurisdictions, that is where we have to be mindful when it comes to transfer of wealth to them. Chances are we will send our children to places like US, Canada, UK, Australia, New Zealand. Now all this well-developed taxation regime also mean they can be very severe taxation regime compared to our Malaysian taxation regime, Singapore taxation regime. Most of these countries would practice what we call worldwide taxation, right? In Malaysia, when I went to Canada, I had a heart attack when I looked at their taxation regime. So basically, in Canada, they will tax their tax resident. Let's talk about Canada because that's where I am. So if you become a tax resident in Canada, you would have to pay tax on your worldwide taxation. Unlike Malaysian, I think even now still we practice territorial taxation. You pay tax on what you earn in Malaysia. So assuming we talk about a founder, let's say a founder decides to transfer 20 million of assets, which may be in Malaysia, some may be in Singapore, to the daughter who has decided to settle in Canada. So of course, the rental income that comes, the dividends income that come, due tax would have to be paid to our Malaysian taxation authority. But she, when she received this 20 million, let's say 5% income, talk about 1 million income, she equally has to report tax in Canada on this 5% income. And she has to pay tax in Canada for the worldwide taxation basis, right? So in Canada, taxation is about 47 to 50%, right? So therefore, you may have a situation where the child pay tax on the onshore income arising situation, also pay tax So if you think about 25% here, 40 or 50% the higher tax rate, she might be a higher tax rate because she's well educated, she's having a good job, she's other income and push it up. So let's say 50%, so 75%. So of course, you would hope that they will have double taxation agreement. If there's double taxation agreement between the country that produces the income and the country where the child resides, then there will be credit given to the taxation that's paid. Of course, there are a lot of provisions that govern it. We have to be very careful about it. But if there is credit, you still end up paying the higher tax. You still end up paying about 50%. So on the other hand, if we talk about the client deciding, all right, is there other ways to help us manage this taxation issue, to be more tax efficient and to prevent tax leakages? One of the ways will be set up a trust offshore from Canada. Set up a trust in Labuan, set up a trust in BVI. So when the founder transferred this identified 20 million assets into the trust structure, instead of transferring directly to the child. Now this the 5% income, 1 million, let's say, that arises within the trust, will accrue to the trust as far as Canada is concerned. Because this trust is set up, contributed by a founder who have no nexus with Canada. Therefore, Canada doesn't deem that trust onshore to be a Canadian trust. So therefore, all income is just arising as far as Canada is concerned. There's no requirement to report or pay tax on this income because it's set up by a founder who is a Malaysian founder. Now, child may need money. I mean, chances are the child doesn't need the 20 million in her pocket every day. But maybe she wants to upgrade her apartment. She requests for distribution, and the trustee feels that is for her best interest and welfare. The trustee distribute 1 million to her. In Canada, if there is a distribution from an offshore trust contributed by a settlor who has no nexus with Canada, the distribution by way of capital is tax-free. So it makes a lot of sense, even from the taxation perspective, to consider different, because children can be in different jurisdictions, US, Canada, New Zealand. So the question is working with a team of advisors, looking at the best way, because the law says you have to pay lawful tax, but the law doesn't say you have to pay the highest tax. So there's always a range that we are always talking about tax compliance. When we do this kind of structure, we are talking about being lawful. Otherwise, it's just going into all the situation of money laundering. We are talking about being an efficient, effective, dynamic structure. So if you work with different teams, so we often do when we work with families, there will be a whole range of questionnaire. What are the objectives? Where are they? Where are the children? Where are the assets? And then we will work with onshore solicitors. If there is a Australian beneficiary, we will work with onshore solicitor to say, look at our trusted, look at our foundation articles. Is it something that you need to tweak to make it more tax compliant, more tax efficient for the beneficiary to receive this? Is there something that the trustee must know in terms of reporting just because there's a beneficiary on that shore? So, and because the family is global, the assets are global, you can't have just one set of solicitor or one set of advisor moving. It's just a team effort. But somebody got to be a quarterback. Somebody got to be, in a way, a project manager to kind of manage, because otherwise the client will be speaking to 3 sets or 4 sets of solicitors, tax accountants, tax advisors. So somebody got to be that. Sometimes the banker could be, sometimes the lawyer could be. So this is assisting the family to rein in the issues. And of course the issue should be dynamic and you have to change accordingly. So I'm running ahead of myself actually. So therefore we say, because of the different characteristics of high net worth family, we say domestic solution may be insufficient to accommodate the global dynamics and the family dynamics. I think this is also captured by Labuan IBFC. I mean, if you have 200 million or 300 million running with you, hopefully the founder will decide, I don't want it to be over within the next generation. But if you talk about our Malaysian local trust, we are looking at, life in being 21 years after life in being, we are looking maybe at 100 years. But 100 years cover two generations, it can be gone. and the trust will have to terminate. But that's why Labuan IBFC have been very proactive as a mid-shore financial center. They have actually amended the act, the Labuan Trust Act. Now, if there's a Labuan Trust, you actually can have indefinite period to cater for this. So there are other jurisdictions too that have amended their act. So basically, it is the various jurisdictions have responded to the growing concerns of family and have made legislative amendment and to follow through to serve the family. So therefore, sometimes domestic solutions may not be sufficient. Definitely, there will be a need to consider laws of multiple jurisdictions. So all service providers need to work together as a team to find what is a good solution. The planning need to be long-term because of the significant capital base. Structure would, indefinite period, would be the most logical. But very importantly, of course, is that we must provide for flexibility. And this is a very strange aspect in my experience working with Malaysian families and Asian families in general. It's not easy to really, in the end, especially working with older generation, like some of my clients are between 60 to 80. So, and to think of doing a trust, transferring the assets all into a trustee that they have only met maybe, in the past 1 year, jittery, worrisome. And they like to know that they are owner. It's so important to them. But once they understand the concept and understand their objectives, I always start with drawing the objectives on the board and always ask them, sometimes they have fear, they trailed off. We say we go back to the objective. They must be reminded that this is an option only. So there's no right or wrong. It's what you want to do with the assets, right? So, but as service providers, we always walk and get them back to the objective and say, all right, you have this concern, but if we do this on your concern, would you achieve your objective? We draw them back on that way. And once they are kind of kind of comfortable with it, they want a very tight structure. They start to say, I want it very tight. Like for example, one of my clients, he has a trust and a discretionary trust, but there's a letter of wishes. And sometimes in the letter of wishes, we will put in a clause to say that if certain percentage of beneficiaries, or the advisory committee, rather, not the beneficiary, because we will have an advisory committee that walk alongside with the trustee. And if certain decisions is made to request the trustee to consider doing certain thing, then it should be that the trustee would consider it. The trustee is not bound. We must remember discretionary trust. The trustee is not bound, but the trustee may consider if it is for the benefit. And then one of this client of mine who say, well, four beneficiaries right now, and he says it must four persons in the advisory committee because it's children, and he says it got to be four. It must be a unanimous decision. 100% of them must agree before they can put this request. So I was saying, times 3 perhaps. 75%, 100% is very high threshold. Even a special resolution doesn't require that. He says, if 3 of them are fools, then one of them at least can pull them back. You see that at least without bothering the trustee with the request. But what about we're talking. What about if 3 are wise and you have 1 fool? It can also that person might be just to put a spanner in the world. You don't know. Sometimes we always tell the client you have to trust the advisory committee to a certain extent. You have to trust the upbringing to a certain. So we always talk about flexibility because it's important. You don't want to put in quite a lot of our trusts that are set up in Penang way back in the Straits Settlement time. Very, very rigid, and it caused a lot of heartache for families who need to do something else. So therefore, trust can get a very bad name. But sometimes I always tell clients, you must understand the structure before we can attack the concept of a trust. Do you really know the concept of a trust that is bad? Or is it the structuring? Because trust is such a dynamic vehicle that allows you to formulate it in different ways, to work with the trustee in different ways. So is it the trust that was set up that is not good? Or is it the concept of trust that's not good? We have to understand that, right? So, and do you base your generation transfer of wealth from a rumors about what somebody else has done and it turned out not too good? So this is how we would want to work with the family to alert them. Right? So key concerns of high net worth families. Of course, we did talk about adverse claims. That's most important. They're always worried if I put everything to the child. You know, remember we talked about the child that migrated, let's say, to Canada, settled down there, 20 million passed on to her. So long as there is ownership tied to the assets are available for adverse claims, the creditors' claims arising from marital breakdown. Because when there is adverse claim, let's say a child is very dynamic, you have bank guarantee, various guarantees. If those assets are in the child's name, the assets become subject to the creditor's claim. But if it is in a trust, and the trust is a trust managed with integrity, very clear, the child is merely a beneficiary and it's a discretionary trust, then the assets are not in the name of the child. So therefore, the key concern is whether you can address that key concern about adverse claims arising from marital breakdown, country and political risk, what happened. Another concern is imposition of exchange control, expropriation and nationalization. When I work with Asian family in various Asian jurisdictions, some concerns are kind of universal within Asia. Some concerns are peculiar to certain countries. And we also, there may be a concern with beneficiaries, concern with beneficiaries with special needs. And this is usually sometimes, you know, clients or advisors will ask, what would be a threshold in terms of asset size before we actually talk about setting up a structure instead of a direct transfer? So of course there's no legal threshold. You can set up a trust even over $1. That's what we do when we first set up a trust. Is $1 US dollars, and then we set up the trust. But in terms of estate planning, global estate planning, I think cost-benefit analysis wise, we would say maybe 15 million, 20 million US and above. We might ask clients to start thinking whether they want to do estate planning processes with structures. But then again, when you have situations like beneficiaries with special needs, then you don't even talk about how much really, because they can't even handle money. So even 1 million to them is something that is beyond the capacity. So you might have to, because instead of in their hand, in their pocket, and they be subject to target for every kind of scheme, you might just have to spend money setting up a trust and paying a trustee to assist them. So therefore, the needs, I always say, determine the decision. And there's no cookie cutter kind of situation. We have to look at the client's needs. So of course, I've already talked about tax minimization. Maybe in home country for Malaysian, in home country it's not so much because we have such a friendly taxation regime compared to a lot of countries overseas. So a lot of them will say, oh, you know, it's okay. A lot of my children are back here. I send them overseas. They've come back. So we have sometimes have to probe a little longer to ask, okay, with the kind of size of estate that you want, that you have, do you think that it should be finished within your children's generation? Or are you thinking that it might be good to go for your next generation, like your grandchildren, your great-grandchildren, depending on the size? And some of the size are large. We cannot deny. Of course, they will say, no way, they can't finish it within this generation. It should be for generations to come. Now, so then the question then is, where would your grandchildren be? Would you know where some grandchildren have not even come? Some grandchildren are too young. You won't know. Now, then it makes very good sense. I always feel that our baby boomer generation here now has a golden opportunity to set up this kind of structure, which may not be passed on. This golden, what would I call it, privilege, this special situation that applies to our baby boomer generation might not pass on to their children. Very simply, most are baby boomers, 50s, 60s, 70s. Chances are they are not moving. Their children may move, or the children may be back, but the grandchildren may move. And the most is they will visit them. But they won't be applying to be PR there, settling there, sitting, so they will probably be here and do the normal visits and have children back. So now if they set up the trust, remember we were saying that if they set up a trust offshore and the trust then make the children, the grandchildren beneficiaries, as the law stands, like in Canada, that trust, because it's set up by a settlor not connected, receipt of fund could continue to enjoy certain tax advantages. But on the other hand, if they say, okay, like in fact I worked with a client who 81, a very, very sharp lady, and along the way she says, I'm really tired going through all this, making this decision. Why don't I just pass everything to the son who is Singapore, and then let him decide what to do, because they're very close family, very trustworthy, good son. So I started working with son is also in Singapore, contributor, he'll be offshore, Then as I talked to son, I heard a bombshell. He says, I'm actually intending, when the youngest one is going to finish Form 5, level 5, I think it's Form 5 in Singapore, it's level 4 or something. I would move with her, because two already in Australia, one in Australia, one in Canada. I would move, depending where she wants to go, and be there. Young enough, the son is young enough, 40s. A lot of investment is liquid, so it doesn't really matter where he is, not a family business situation. Now that becomes very difficult, because if she transfers it to him, and then he then set up the trust. Now when he moves to Canada, because it's there is a nexus. How the law looks at it is quite different from one that never comes onshore. So therefore, it is very, I really feel that it is this kind of situation may just be with us baby boomers for this. And passing on, you may have children, but you must remember the second generation to the baby boomers are 30, 40. They still have lots of vision, lots of time, energy to move where they need to be. So it is much better to have our founder, who is more laid back now, who decides not go anywhere, to be the one to contribute into the structure. So, so moving on, of course, then other key concerns of a high net worth family is, how do you transfer your wealth? Do you divide your family wealth among family members of the next generation? Basically just each one 30%, 20%, or do you have what we call a stewardship of family wealth for succeeding generation, a stewardship way, someone holds it to benefit generations to come. Again, like I say, there's no right or wrong. It's their money, what they want to do, but what we as service providers should do is just to inform them of the options, what are available, what are other families doing, what can be done. If they want to do the division of family wealth among family members, chances are global estate planning really would not be what they're looking at. They won't be doing a structure, right, to pass on. But you may still need things like very robust shareholders agreement. You may still need to do that. You might want to make sure families have different members who receive it have multiple wills, right? Because if a child is in Canada, you pass on property to him in Malaysia, he should do a will in Malaysia for the Malaysian property, he should do a will in Canada for the Canadian family. So these are still things that needs to be done, but not so much role in terms of global estate planning that today we are talking about. But definitely the second one will be where we should be alerted to say, if you want a stewardship way, let's look at different options. Family business. Now, the clients that we act for, I would say 60-40% in terms of the category of the assets. Some families, the assets are really just pure investment. It may be a financial investment, property investment, nothing that ties in with an identity of their business. But a lot of families in Malaysia that we see have what you call family business as one of the core assets, where maybe 3G. In Penang, the family we act for is already 4G. The fourth generation is already in there working shoulder to shoulder with the various generations in the family. So now this family business is then becomes the identity of who the family is. So planning for clients who have assets which are liquid and can move anywhere, and planning for families who have family business as one of the core assets have different challenges and different approaches. So of course, like I say, for family business, you want to say, can I avoid fragmentation of ownership? Right? Because if you pass on directly, as each one owns it, then you from 3 brothers becomes 9 grandchildren. So we talk about the founder, the sibling partnership, we have the cousin partnership, is split down. So one of the families that we are acting for has 63 shareholders. It is so difficult. Young members who come back, very interested in the family business, have very good ideas about what needs to be done, but they don't want to be to work in the family. Because even though the packages may be good, but they realize I've got 63 cousins, uncles, grandnephews to look at. One of them may be holding 0.5% of the family syndrome heart share. I write email to them, none of them respond to my, it's a very difficult situation. So, and it is real, right? We all understand that. So, but if you put it in a structure, 100% in there, you're dealing, they know the board, the hierarchy of reporting, they understand that. And some of my clients will say 70%. We release out 30% to float among families that come back to work as a motivation. Some will say 100%, it all depends. But definitely fragmentation of ownership is very much now that family business have to look at. And then that's what I mentioned. How do you encourage participation in management by the succeeding generations? So with all the key concerns that we spoke about, asset protection, taxation management, preservation, all this we are talking about money, asset value. You say, well, perhaps the client may want to look at an asset protection solution, a structure to help to address their issues by putting their assets in a certain structure, whether it is private trust company, whether it is a trust, or whether it is a foundation. So, but an asset protection structure. But the other key concern, preservation of family as a whole. This is where we talk about the soft issue. Clients want to know really legacy of family identity. How do you pass on your family identity? Family vision, family values and tradition, family unity. In Malaysia, as in most Asian countries, in all these previous generations, we have been looking at passing on through our tradition orally. We call it the oral tradition. Families come back for Chinese New Year, we come back for Qingming, we come back for all the different activities that go on, public holidays that come back, celebration Hari Raya. It's all together, that even though they may be in different states, but they come back together. But this is no longer a given because families now are all over the place. So to come back just for a particular occasion may not be, you may have half of it coming back. I remember this client of mine in Penang, he says, I told them at least once a year, the Chinese New Year at least must come back. Say, oh no, some of them by the time they come, they go to Bali. So clients say, I told them Penang is also an island, why do you need to go to Bali? But then that's how it is, the younger generation, they decide to do different things. So the question now is, how do we have a way to still, although we don't have an oral tradition, method of passing on, can we find ways to still glue them back together in a more organized manner? Because if you organize, someone say, oh, let's meet in Bali, you can't have everyone. But if you set up a structure where the family, the trustee or the foundation would say, I will set up a certain, the letter of wishes say, would you consider setting a certain percentage for family activities? Like a client of ours went over North America in Hawaii. This study shows that when it's all paid for by the structure, 70-80% attendance is almost a given. Because we call this DNA networking, right? We tell children you must network, you must extend your community and all that. This is DNA networking. Cousin meeting, North America meeting someone who's working in South America. There's a lot of value trapped within the family that can be done when you have families together. So we speak of a situation where is there a way to continue this going? And family preservation, like how do you provide processes for family decision making and resolving conflicts? Keeping members appropriately informed and connected. And these are the other issues regarding family business company. A lot of members in a family business tend to mix up their role between whether they are shareholder and management and family. You know, I'm sure you all have seen the three circle, right? So some are families, but they are not shareholder in a family business, nor are they in management. But some could be family and shareholder. Some could be family, shareholder, and management. Now, the role needs to be clearly defined because sometimes in the family meetings, we all know they go back for dinner at grandmother's house. A shareholder will bring up certain things to question the board of directors on matters that really is the board concern. And if you don't, and if the families are all on the same shore, you have quarrels, you have disputes, which are all very good because the issues are ironed out. But if families are in different shore, they might not communicate on the suspicion on certain issue. Like there's a family that has 3 children. One of them returns to work in the family business, doing very well. Second in the row of 3, but one is a surgeon in Australia, another one is an engineer in England. 3. The company did very well, but because of an expansion plan in China, they decide no distribution of dividends, keep the borrowing gearing low, takes the money, invest in China. Two of them overseas heard, oh, we heard it's doing very well, but no dividends this year. But we heard, brother, big payment apparently, you know, so what's happening there and all that, very kind of unhappy, but never talk about it. But they forgot. I mean, the brother also did not get dividends, but he got a big bonus for being the MD, right? He led the company very well. He worked. He got a bonus. I mean, each of them get their own bonus working as a surgeon or working as an engineer. But this kind of thing, when you are onshore, everybody is together, there will be occasions you bring it out. How come you did this? How you did that? But then when you are scattered, so-called, in different areas, the opportunity for that might not. And a lot of us, Asian upbringing, we tend not to want to talk about. We tend not to want to be confrontational, email and all that kind of thing. So that's very important. How do you keep them? The word is appropriately informed. You don't tell everything. Like in family retreat that we have in the charter, we draft charter and talk about family retreat. We talk about policy about what you should talk about and what you should not talk about. But children, we always say children, chances are they're not born bad children. But when their expectations are not managed, that's when they think entitlement. They will ask questions all over the place. They will expect different things to fall. But if right from the start, you have a good structure, you have a system of educating them into it, you have a family charter, which, like the family charter that we draft, most families will say by 18 years old, the child must sign before 2 of the advisory committee members. So the child reads through the family charter, the value system, and then you have family retreat where advisors may be brought in, like there was a family retreat, new advisors brought in, just do small money management for the children between 12 to 18 years old, small money management classes. I shared this before where that they are given, each child was given $1,000 US dollars to contribute to charity, and the only requirement is 1 year later they have to write a report to say who they give to, why they give to the organization. So, and of course, the boys never did any homework. 1 year later, the boys is like scattering, you know, writing email to female cousin and say, who do you give? Why? Give me the notes about this organization that you put. So, but there's a lot of interaction between the young ones, different jurisdictions, talking, right? So they give a report, and one of them, in fact, give just $50 US to one of the biggest organizations, and was invited by the local board to me over $50 because she took an added step. She not only gave, she wrote a letter accompanied to the $50 that she spent, saying why she gave you that kind of thing. So that board felt it was very innovative, so invited to me. So these are precious, precious experience for the young one. And if you have significant wealth, you can do it. You can use your money to work for you, right? So, and then we talk about promoting communication and trust. How do you do that? Avoiding family disputes in public and in court. A lot of time for families, we talk about signing confidentiality agreement. We talk about signing prenuptial, postnuptial agreement. It's part and parcel. Some families have it as part and parcel in their family charter to say that every child, every beneficiary, so-called, that gets married would have to sign a prenuptial agreement. Now, this becomes easier topic to talk about between this couple that come together. It is, the child can say it is not you, it's just that it's part of the family governance in the charter that we need to do that. So it takes away the age, it takes away the sharp edge of saying, oh, Mary, we're talking about money, prenuptial, but it's just part and parcel of the family requirement. So it assists a touchy subject to be brought on in a very broad and open way, right? So then preservation, we talk about preservation of human capital, yes. Yep. Okay, so where were we? Preservation of human capital, a question of individual welfare and achievement, forming, like for example, when we do charter, we will work alongside families to talk about employment policies for the family business. Of course, these are things that we don't do it on our own. We work with family and other advisors to formulate it. Is it everybody with blood of the family will be employed? Or is it has to be someone that has the correct qualifications? What are the qualifications? Does it need a couple of years experience outside before joining? All these things are important so that they know what to expect when they graduate. I am, let's say I am a Wong, big family, the Wong family is a big. Does it mean that I walk in, I expect a place for me in the family business? Or do I have to earn it, right? So, and a lot of times our families, we know that we run it with a very organized approach. Sometimes it's touch and go that they turn out so well, right? So we are saying that with the big family, with a big amount, you got to look at it in a more organized way for both sides. Good for the family business and also good for the children because they grow up knowing if they are interested in the family business, they could sign up for internship within the family. Families have started to do that, or internship with a similar business that the family know that put them there. So these are the things that you can, with money, you could look long-term ahead, not backwards, but long-term ahead to see what could we do. Education and preparation, leadership role. A leadership role also, actually, my heart goes a lot with high net worth families' children. Because sometimes the burden can be very heavy. The expectations from the family, from the outside community, and they really are ill-prepared to shine in the role that they are expected to. So, and a lot of them will labor under the impression that they have to come back and work. And a lot of them, and we know, right, in our walk of life, we know there are a lot of children who say, because the family want me to work, but actually their heart belongs elsewhere. So the question is, if you have a big family structure, they don't need just to participate by coming back. You could set up a charity foundation. Your children, those that are not back working in the family business, can be a board of directors in the foundation that you set up. They can continue to know how the company fares and they can continue a part of the family dynamics because you have been intentional in inviting them to come in. So succession planning, even children have to think about their succession planning because the amount that they receive is expected to also to last. So the question is, how do you help them to do that? So we talk about protection of privacy and security of family members, protection of confidentiality of family affairs, organized approach to philanthropic activities. We all know that, right? When you give, you are really blessed in return. So we would talk with clients to say, instead of doing what a lot of people do, checkbook giving, you just give from your checkbook. Studies have shown over and over again that a sustaining approach towards giving, a very organized way, bless both ways tremendously. First, the organization could look to you for a sustaining support. In turn, you can play a role, the children can play a role in adopting various organizations and interacting with them. And if you do give a large amount, a lot of organizations will be very happy to respond to your need, like instead of just giving you their annual report, which, you know, the family would have enough annual report from different corporate entities to look at. But instead of going, you could say, when I give to this particular branch of your organization, I want a report on this particular branch. How did it work? You know, if I want to give on education or drainage problem in Thailand or in East Coast of Malaysia, I want a report particularly focusing on this. And if your amount is reasonable and sizable, they will do it. And in turn, your children can participate in a meaningful way in these activities. So when we talk about, you know, preservation of family, we would say do a family governance structure. So you have an asset protection structure that looks into their money and their assets. You have a family governance structure that rope in your family together as it grows to continue to tap the rich resources that you have within the family. So commonly found components of estate plan, like we know, we say that usually is a last will and testament. A lot of clients, they have done a will. You know, so is that sufficient? Well, we have seen various reasons why it might not. First of all, of course, a will is subject to challenge. We must know sometimes a client, I remember when I practiced, I had a will that was into 47 drafts before he finally signed the 48th draft. So it is, you want it, because you want to kind of speak from your grave, right, in that sense. But will has its limitations, because if there is a challenge on the will, our Asian family may have multiple families. When we have challenge in the will, the one who writes the will is no longer around. And therefore, your wishes and your intentions may not be understood the same way with children from the second generation situation. And of course, like places like in Canada, we have what you call wills variation provision, where actually dependents can also challenge the will for not working, not providing them reasonable sustenance, right? So will has its limitation. I'm not saying will is a must. It's the most bottom net that we do. Even when we do holistic global estate planning, you should still have a will. So that is for sure. But is it sufficient for a high net worth family? That's what we have to ask them, right? And of course, if in a will, if you give direct bequest, directly, in a will, you just give to the children directly, then we talk about the same old problem. No asset protection. The beneficiaries owns the asset personally. There is no tax efficiency. The beneficiaries in taxing jurisdiction personally responsible for taxes. There will be fragmentation of ownership because you are just giving them directly in, you have got 9 grandchildren, you give them 9, so fragmentation. And then there's no stewardship of assets across generation because whoever that receives it is totally entitled to spend it all away. So some would go as far as doing a testamentary trust, and but that's a good step ahead already, because testamentary trust means you set up the trust after death, and the trustee will then run the trust, administer the trust according to what you have stated in the will, right? But testamentary trust in Malaysia has limited lifespan. Now Labuan now has indefinite period. So And then we talk about the compliance with requirements of forced heirship. So forced heirship could be our Sharia forced heirship. In Philippines, they have also forced heirship called legitim. So different countries have different, so sometimes clients may wish to consider benefiting certain a little bit more solely because these children have walked alongside them, these children have looked after all their needs, have helped them to expand the business. So you may want to consider, and different jurisdictions allow, offshore jurisdiction allow certain structure to be set up and then be able to withstand forced heirship claims. So, and then of course we say that a will is not sufficient to deal with most of the key concerns. You have inter-vival trust. Now, some clients will ask me this, Millie, should I set up an inter-vival trust now or set it up in my testament? So that is a testamentary trust. So, of course, one obvious element to consider is that the client who sets up inter-vival trust now is the one who is able to sit with the trustee, talk about the terms, set it up, have it running, maybe even put quite not much in there just to get it going, but start talking with the children about a vehicle that's already there. So they start educating them into what trust is about, how do you deal with trustee? You're just a beneficiary, you don't give instructions, you know. So things like that could be done in his lifetime. Now, he is the one that is, in a way, the lights of the family, right? The founder who make all that. So when you do a testamentary trust, strictly speaking, when the founder is gone, the visionary is gone, the family is in a grieving process, you know, the family might not know exactly what to do with the trustee, you leave it a little bit to the disadvantage in that sense, not capitalizing your presence when you're with them. So again, no right or wrong, but we should alert the clients to say, you know, in testament trust, there's just so much you could say in your will. Well, now you can sit with the trustee and trustee can alert you. What about this? When this happened, what do you want? Certain things you might not remember, might not think of when you are starting with the project. But when you sit with an advisor the advisor will alert you, you have a lot of experience like this, what do you want to do? And then, you know, client will say, oh, I didn't think about this. That is a good time. So inter-vival trust, we say with appropriate features, is definitely better than just having a will. It allows asset protection. So in our experience, we always say that existing estate plans may be generally incomplete and may not address the key concern. A lot of times planning may be just domestic, not global. And transfer of asset is often direct, either by gifts in their lifetime or by will, and not indirect through protective structures. And this is very important. The focus, a lot of times, the clients still work on this focus. Focus is on who will own the assets, not on how the assets can be used to benefit the family across generation. A lot of times when they sit down with clients, they are still starting, they want asset protection. They want their children not to waste the assets away in their lifetime and all that. But they still end up talking about giving to who will get what. I want this child to get what. So then it's not so much how will my asset be benefiting my children across generation. It's on who. Still the emphasis. They keep tripping back onto that growth. And of course, we say that. We say a lot of time in planning, the assets receive more attention than the heirs. Founders, our very successful and dynamic founders, kind of expect the children to just know what to do. And they may go ahead with organizing the structure for the assets, but we say we have to look at the heirs as well, their training, their leadership. How do you manage assisting them along the way without indulging too much, but how do you think manage to help them when the need arises? Because they are, after all, from a good family. And it would be nice that you can bless them that way, but how? Okay, I think, I will do this after the coffee break. Okay, thank you.
Ladies and gentlemen, we'll have a short coffee break and we shall see you again at 10:50. Thank you.